All right then, time is on. Monsieur Professeur Jacques Ziller, fellow fellows, Ramon, and other distinguished participants, it's really my great pleasure to come this afternoon to talk to you about my work. Now, I don't know whether it's a curse or a gift, but someone had to close these sessions, and in doing so, what I can promise to you is to try to keep it as interesting and as lively as possible. Now, to help me do that, allow me to refer to a first rule. Lawyers like rules. As a matter of fact, it's not so much a legal rule than a rule of public speaking. Some of you might have heard, might have encountered this basic principle, the KISS principle. Anybody? Keep it simple, stupid. I actually personally like to replace the last S by my Christian name, Stephane. It's less insulting. Now, in substance, my research, what I've been busy with for the last few years, is interested in the relationship between the international and the national. Now, in presenting that, to keep it simple, Stephane will use a case, a judicial decision by the Supreme Court of Canada that will help me put things into context. Now, some lawyers here, maybe you'll recognize the technique, pretty usual in the common law tradition, the Anglo-Saxon world. We study law bottom up. We look at a situation and how it made its way to the highest instance of the land, usually. And we try to identify, doing that, the legal principles that will last until it's changed by another judicial decision. Very common law. Now, the case that I will first set out for you, spend a little bit of time on it, is a decision by the Supreme Court of Canada in the Suresh. That's an R. Suresh. Okay, Suresh, the whole citation, Suresh versus Canada, decision of 2002, 1 Supreme Court report, page 3. Now, it was rendered at the very beginning of the year, precisely on the 11th of January 2002, and that date is important because in legal terms it basically means that it was rendered, that it was handed down in the immediate aftermath of the terrorist attacks in the United States. In law, with the hearing, delays in decision making and all of that, 4 months is like an instant. Now, usually cases are presented, I was mentioning to you, in order to get legal principles out of it. It usually involves, as a matter of fact, a participation from the classroom, from the group, to set out the basis and to help out extract the principles. Today, however, I'll ask you your indulgence in keeping your intervention very as little as possible so that I have time not only to set the table, but to have my meal with you on it. Now, very briefly, the Suresh case, what it was all about, to put it in a box, as we heard yesterday, it was really a decision in the field of immigration and refugee law. Mr. Suresh is a national from Sri Lanka who arrived in Canada, Pearson Airport, Toronto, in October of 1990. He asked and got right away recognized the status of refugee pursuant to Canadian legislation, federal legislation. That legislation, by the way, is actually based on an international convention, on an international treaty, the Refugee Convention, to which I'll return in a moment. Now, about a year later, in the summer of 1991, Suresh asked for the procedure to begin, the procedure to become a landed immigrant. That procedure, some of you might be familiar with it. It's sort of similar in many countries. The bottom line is that it takes time. in the meantime, unfortunately for Mr. Suresh, and that is some 4 years later, towards the end of 1995, that procedure was abruptly put to an end. And as a matter of fact, what happened is that the federal authorities in Canada started a procedure to deport Mr. Suresh. On what basis? It was discovered in those years, because when you apply to become a landed immigrant, of course, they check your background and your past and your activities, etc. It was discovered that Mr. Suresh was an active member, it was alleged and proven to the satisfaction of the federal authorities. He was an active member of the Tamil Tigers, a well-known, well, in that part of the world at least, terrorist organizations which mission is essentially to overthrow undemocratically the government of Sri Lanka. Now, it took a few years, but 1997, a final order by the Minister of Immigration and Refugee, federal level, that basically ordered the deportation of Mr. Suresh. It was made pursuant to a particular provision. Section or article section 53(1)(b) of the Immigration Act. That says basically this, that the minister is empowered to deport anyone on security grounds. So far, not so problematic, but it continues by saying that it can, even though the deportation means that the individual will end up in a country where his life and freedom might be in danger. And that's the bit that is more problematic. In Canada, like many other democracies, to make an easy parallel, like in the United States, there's a Bill of Rights. We call it a charter. You can call it a bill. People would think it would be in the United States, so we call it a charter. But essentially, it does the same thing. It gives a constitutional protection to certain rights. Some of these rights are put in the broad category known as criminal rights, the rights that usually people accused of criminal offense are entitled to. One of these rights, so that is of the Immigration Act. The one that is relevant to that case is Section 7 of the Charter. Now, what does it say? Section 7 of the Canadian Charter of Rights and Freedom, essentially that everyone, be it Canadian or not, so long as you're on Canadian soil, everyone is entitled to life, life, security, I have to double check. Life, liberty, and security of your person, and those rights cannot be infringed upon except in accordance with the principle of fundamental justice. Now, coming closer to the issue that was at bar in that case. The whole thing actually boiled down to the interpretation of Section 7 that provides that constitutional protection, and it needed to be decided what was the scope of those principles of fundamental justice. And essentially, when asking if Section 53 was valid, the court had to decide if the exception made in Section 53(1)(b) of the Immigration Act, allowing the Minister of Immigration to deport even in cases where the life and freedom of a person would be at issue, if that was in conformity of that constitutional protection. So principle of fundamental justice, does it apply to the situation at bar where the deportation means essentially that the individual is at substantial risk of torture if deported in this fashion? Now, so that was the center, the issue at the center of the case. To decide that issue, the court had to interpret Section 7 of the Charter, but not in a vacuum. That's the modern trend in many common law jurisdictions, including Canada, but also the UK, New Zealand, Australia, whatever, is to interpret even constitutional provisions. Oh, and I should say even the United States of America, as it was proven recently, 2 years ago. Now look at international law to inform the interpretation of constitutional provision, in this case, Section 7 of the Charter. So in that case, international law confirmed a broad interpretation of Section 7 of the Charter that essentially meant that there was a blanket protection for cases where a deportation would involve a threat on the life and liberty and security of the person. Now, I pause here in my explanation, my coverage of the Suresh case, to go right away, or to go for the first time, to really that interaction, that was a table that needed to be set. Now it's set. Now let me tell you a little bit about that general issue of the interaction between international law and national law. You see where it comes in this case. It comes at the level, at the point of the interpretation of Section 7 of the Charter. Now, it's heavy. I guess I'll just square. To help me at first talk about that relationship between the international and the national, there's certainly at least a few historians here that can help me out on this one. Let me ask you, I've been talking enough, let me ask the group, historians in particular, if 1648 rings a bell to you, especially in the history of Europe. It was the year of the Peace, I've heard it, of Westphalia. Peace of Westphalia that marked the end of the so-called 30 Years' War. And we're told that Westphalia is associated with a change, a fundamental change in the way that nation-states are organized, are viewed as doing. We're told that it divides the old regime, the way of organizing nation-states, to the new regime, as if one event, the Peace of Westphalia, could be so significant. Well, I pause here. Of course, the old regime did not know that it was old until the new regime told it that it was old, but that's another issue in which I won't go into. Essentially, 1648, for my purposes, what's important to highlight is the significance of it for the purpose of analyzing the interaction between the international and the national. Now, Westphalia, Peace of Westphalia, is associated with the basic concept of sovereignty. It is said that at Westphalia, sovereignty, that was an old concept that had been, I guess, articulated internally by many, but among other important scholars, Jean Bodin in the 16th century, that sovereignty at Westphalia in 1648 was externalized, exteriorized, essentially meaning that the sovereign was not only the holder of supreme authority internally, in other words, that he did not share authority with any other actor internally, but that sovereign became also the holder of supreme and exclusive authority externally, meaning that in its relationship with other states, it did not have to answer to anybody, not to the Holy Roman Emperor, not to the Pope, that it had authority, perfect control on what was happening, both internally and externally. Now, having said that, what does it mean, and at this point I guess I will have to erase some stuff. What does it mean for the relationship between the international and the domestic? It means that for the longest of time, although some people are challenging that for some years now, but for the longest of time, and I personally believe it's still the scheme, for the longest of time, I've said that 3 times, the international is seen as being separate and distinct from the national. There would be, I like to express it, my students at least, in terms of bubble. There's the bubble of international activities, international actors, international subjects. And what international law does is to regulate the activities that is happening in international law inside that bubble. Separate and distinct from the bubble or the jurisdiction, the activities, legal and else, within sovereign states. What's happening there is the exercise of external sovereignty. What's happening here, whether the UK, US, Canada, biased, what is happening within each national jurisdiction is separate from what's happening in the international law. Now, it doesn't mean that what is happening in the international law bubble cannot prove relevant to what's happening within the domestic law bubbles. It just, you gotta be kidding. Oof, all right. Now, what it means, though, is that there are some common activities and some of the rules, usually constitutional in common law jurisdiction, deal with how international legal norms makes the jump, bridge the international to become relevant to the national. Right. Now, in 5 minutes, I'll have to say very briefly, obviously, a word about the different sources of legal norms. To make a long story short, there are two principal sources of international law: treaties and customary law. Those two main formal sources of international law obey to or follow two different theories when it comes to the incorporation of the international legal norms domestically. One is called the monist. That will be familiar to some of you. The monist logic of incorporation. And the second one is the dualist theory or logics of incorporation. Again, to make a long story short, custom follow the monist logic, while treaty, international conventions, follow the dualist theory. The dualist theory essentially requires an explicit involvement of the domestic authority in order to make the international law norm relevant domestically. It essentially, in common law jurisdiction, means that you need implementing or incorporating legislation. The parliament of that domestic jurisdiction will enact a law that will bridge the norm and make it relevant domestically. Now, if you're dealing with customary law, the judge, in order to apply it, will not look for a piece of legislation. They'll simply look at the international norm. So in that sense, it's monist. It's sort of connected without an action by the national jurisdiction. Again, as an image, I like to think of the monist theory as a matter of fact, for customs. As I explained to you, there's sort of a bridge, a permanent bridge that is built between the international sphere and the domestic sphere. While for treaties, you need to take the ferry. Every time you have a new treaty, there's a little ferry. That is really the piece of legislation that will make it relevant to the Canadian domestic jurisdiction. Back to Suresh now. Probably have 2.5 minutes left. In Suresh, the problem was that when dealing with the influence of international law on the interpretation of Section 7, is that there were several treaties, the status of each one being different. Just to quickly enumerate them, there was the Refugee Convention that I already alluded to. There were two other instruments. The Convention Against Torture, CAT, and also the IC, the International Convention on Civil and Political Rights, International Covenant on Civil and Political Rights. Now, The problem when using those norms domestically is that not all three treaties had been implemented domestically. Tell you the whole truth. The first one was, and it was the only one, the Refugee Convention, had gone onto the ferry to become relevant directly for Canadian judges. The two others, Canada is a party to those agreements. Canada has ratified those treaties, but has failed to implement, to adopt legislation to make it explicitly relevant for judges to use in order to decide a case in a Canadian jurisdiction. Now, did it prevent... last bit of information, extremely important, is that all three treaties did not say the same thing. The first treaty, the one that is implemented, the Refugee Convention, essentially said that it was prohibited to deport to a country where the life and security of a person is at risk, where there's substantial risk of torture, for instance, except in cases or in situations where the national security was at stake. And it was alleged in that case that it was exactly that, the situation. Now, so a prohibition, but with an exception. The two other treaties essentially was a complete prohibition without any exception. So it was saying total prohibition to deport if there's a risk of torture, and no exception. Now, at the end of the day, I mentioned to you, the Supreme Court of Canada interpreted Section 7 of the Canadian Charter as including a blanket prohibition, a complete prohibition on such deportation when there's a substantial risk of torture. In other words, it favored the international legal norm that had not been implemented domestically over the norm that had been implemented domestically. So ever since that case, international legal scholars that are not busy with more important things have been asking, does it really shake the basic principles of the dualist approach when it comes to the use of international conventions domestically? Now, the short answer or the easy answer is to say, yeah, absolutely. We're in ages of fundamental change. The paradigm of Westphalia has failed, has died. Look at other examples in common law jurisdictions. However, there might be more accurate or simpler explanation, like the fact that the prohibition against torture is not only a conventional norm, a norm based on treaties, but it's also customary law. It exists in parallel, which means that in real fact, the court, what it did is to follow the monist theory, because even it didn't really say it so, said it in such a way, the norm that it was dealing with was also customary. Now, having said that, for the purpose of my research here, I will examine the first possibility, that there might be something more than the easy explanation for such a decision. I will look into whether, especially in light of the European experience, we're not somewhere sort of in between. And the European experience is extremely rich in that sense because the EU is somewhere here. I hope that Professor Ziller does not disagree too strongly about this graphic. EU. Union. It's got, for instance, I know I'm past my time very shortly, Ramon. It has, among other things, two fundamental doctrines, principles, that of direct effect and that of supremacy. Now, for a continental lawyer, international lawyer, it might not be so surprising, but for a common lawyer, those principles, and still nowadays, I don't know, it's been 45 years that de Gaulle finally let the UK in the Union. Some lawyers still have fundamental problems with allowing an authority outside the UK dictate some kind of rules that will be directly applicable and applicable over domestic legislation by judges. So essentially, I will be looking at that new, well, not so new, but for North American, somewhat new beast that is the EU with those basic, two basic principles, and how really it might be something that is useful in order to rationalize, to articulate some kind of new way of considering the relationship between the international law bubble and the domestic bubbles. All right. Thank you.